Hello and welcome. So glad you joined us here today. My name is Chris Nudo, and I am an attorney in Illinois with offices in Arlington Heights and Elgin. Our practice focuses on estate planning, probate, real estate, and business transaction law. We have worked with many churches and not-for-profits over the year as well. And it is our pleasure to spend a little bit of time with you here this morning and going over a topic that I know is near and dear to more than 50% of the people that are watching today. So let's just jump right in, shall we? Our topic today is how do parents from mixed marriages deal with their estate plan, which that would be like your will or your trust, things of that nature, as it relates to distribution of property to your children from different marriages. So that's a great topic. We know that today in America, the divorce rate still hovers over 50%, which means that more than 50% of the clientele that comes and I work with are coming in not with the original marriage, not with their first marriage, not with their second, sometimes even their third. And there are children from each one of those marriages, and we need to dissect, evaluate, and properly plan for those types of families. So let's just jump right in. So a little, one of our agenda items for today is key areas in which to consider when planning on providing for your children in a mixed marriage. And we need to have some definitions regarding mixed marriages and marital assets as it relates to Illinois. Now, if you're watching this video or you're watching it live this morning with us, and you live in Wisconsin or Arizona, California, or any other state that has a community property law with regard to marriages, much of what I'm going to tell you today does not apply. But in Illinois, we are a separate property state. And what does separate property state mean? What it means is if you are married, all the assets that you brought to the marriage, or better said, acquired before the marriage, as long as you keep them separate, meaning you don't commingle them in the marriage, and we'll spend a minute discussing that. And if you inherit any property that you keep separate and do not commingle, then the property that you brought to the marriage that was not commingled and the inheritance that you kept separate, even if you were married at the time, remain separate, and these assets are not considered marital property. So let's talk about the concept of separateness. So it's easy to use examples to define this stuff. First, if you come to the marriage with a big savings account and it's just in your name, and you do not add your spouse or partner as a joint owner on the account, then that account is separate. However, if you add your spouse to that account, now it's commingled. If you take the money out of your savings account, put it in the joint checking account between you and your spouse, it's commingled. So separate really means separate. Commingled means where your spouse has equal access to the asset. So now that we've defined that, people from separate marriages, no, people from mixed marriages tend to have many assets that they are bringing to the marriage that they acquired either in their first marriage or sometime prior to the marriage that they are in. And if there are children from the first marriage, second marriage, third marriage, depending on which marriage you're on, and you have children from each one of those marriages, then segregating and keeping separate property and how you treat those children are going to need to go through various considerations. So now, one of the things I wanted to talk about was, do you always need to treat each child equally? And the answer is no. In our example this morning, we will say that a wife has 2 children from her first marriage, and that a father has 2 children from his first marriage, and the 2 of them have a child together. So there are 5 children, 4 from the wife, 4 from each husband and wife's first marriage, 2 apiece, and 1 together. What are some considerations when that couple comes to me and we want to discuss estate planning? Well, the first is, let's talk about the children that the current husband and wife have together. That's 1 child. That 1 child has 1 mother and 1 father to care for that child. And so when planning for that child, we do a simple analysis of, if mom and dad are not there, what is available for that child in the way of inheritance? Now, we don't necessarily quantify that at the moment. We just identify that there's 1 set of parents that'll be available to help that child in any way or fashion growing up and raising them into adulthood, versus, let's talk about now the children from the earlier marriages. First, we'll go to the wife. We discussed in our example that the wife had 2 children from her first marriage. And what do we know? Well, in our example, we can speculate that the father of those children still exists, is working, and is a productive person in society. And we will, for this example, assume that the father has his parents around and are productive people in society. And we have mom. And so what we find is that the children from the first marriage end up having a larger influence or larger scope of people who are available to care for the children from the first marriage, because there is an existing father, there is now a stepfather, there are grandparents on both sides of the equation. And so there's more people who have the ability to step up and care for these children from the first marriage. On the husband side, it may or may not look exactly the same. For example, if the husband had 2 children from his first marriage, but his first marriage did not end in a divorce, but he is widowed, then the mother of his children from the first marriage is no longer available to provide. As you can tell from this little example that I've described, it's very complex. It requires analysis at the nuclear level of each family unit, and the analysis of what parents are still alive, what parents are capable of providing, What are the family values of each one of those parents? What are the assets or the socioeconomic status of each one of those parents? How big is the family? If we reverse this entire example and we say that the current married couple has 4 children naturally born between the two of them, and just the wife brought 1 child from a previous marriage, this analysis completely changes, because now we have 4 children and that have just the one mom and dad to care for them and raise them to be productive people in society. And we have only 1 stepchild for the husband and one child from the previous marriage. The whole analysis it still needs to be done and needs to be evaluated to determine what resources are available out there for each child. But because we now have more children born of the current marriage versus the previous example, the analysis now will weigh more heavily on the current children and less on the stepchild. Let's see. So during none of this time have we discussed how, once we have this information and we've done the analysis and we determine the need, how do we effectively plan for the death of a parent? Well, first, I'm going to say that trying to do this planning efficiently and effectively with wills in Illinois is very difficult. Now, we can definitely craft the language in a will. We can make accommodations for different children from different marriages, taking into consideration assets, resources, and other family members that we just discussed. But the likelihood is we will end up in the Illinois probate court. And trying to manage and administer this estate through the Illinois probate court, where there is many children from mixed marriages and many parents, can be an administrative nightmare, both in time and in cost. So if we don't want to have to handle it through our court system and probate, we don't want to use a will, but rather we want to use some other vehicle. The most popular vehicle in Illinois to deal with these things are living trusts. Now, if you've watched some of my other videos, you know that the living trust is an estate planning asset that does all the functionality of the common will, but then does so much, much more. And the very thing that it is known for in Illinois is a tool that avoids probate. And so when we start planning for people who are a mixed marriage situation with children from other marriages as well as children from the current marriage, living trusts are the tool of choice. Now, we need to bring this all together, because in many instances in a mixed marriage, we have separate property, which is what we started this discussion with. We have mixed or commingled or jointly held property from the current marriage. And when we mix the separate property, the commingled property, children from prior marriages, and children from the current marriage, this requires an extensive analysis and diagramming to ensure that we prepare the adequate estate plan that protects all interests. First of all, let's start with this. In many instances, but not all, we plan these types of situations with individual trusts, not joint trusts. Again, a little definition. An individual trust means that a husband has his own trust and a wife has her own trust. This gives us the greatest flexibility in planning on each side of the family versus a joint trust, which is one trust for the husband and the wife together. This limits our planning ability. Now, note, I say usually because there are many instances in mixed marriages where I will use a joint trust. And briefly, those examples are where the asset, that keeping the assets separate is less important. But let's go to our individual analysis. So the husband wants to take care of his children from his prior marriage. The wife wants to take care of her children from her prior marriage. And together, husband and wife wants to take care of their current children, lots of children. So how do we do this? Well, the beauty of using individual trusts is that we can design the husband's trust so that it cares for his children as well as his wife, as well as his current child with his current wife. And when done appropriately, there's no risk of being disinherited. So let's talk about that for a quick moment. One of the big concerns is that a child from a prior marriage can lose their inheritance. This could be intentional or unintentional. Happens every day. How does this happen? Well, mom and dad, their marriages fail either by divorce or because one of the parent dies. The surviving parent goes ahead and gets remarried. At some point, that surviving spouse might die, leaving the step parent as the survivor, as the surviving spouse. The surviving spouse typically does not recognize the children from the prior marriage or does not value as greatly the children from the prior marriage. So then when he or she does her estate plan, they may not include the children from the prior marriage. And again, this can be intentional or many times unintentional. But the fact of the matter is, without the proper planning, that child just was disinherited, which I can tell you from talking to many children who were left with nothing when their parents died as a result of mixed marriages. It's a very hurtful event. So if we do the proper planning and we put protections in place so that new spouses, whether intentionally or unintentionally, don't have the ability to exclude children from prior marriages, then we have accomplished the necessary goal of making sure that a child doesn't get disinherited. Now, people ask me, do distributions have to be equal? Meaning if I have a child from a prior marriage, my wife has a child from a prior marriage, and we have a child together, and do those three children each have to get a third of our estate? And the answer is no. Because your child from the prior marriage supposedly has another parent and grandparents, aunts and uncles. And So oftentimes we will leave a greater amount of the assets to the child that is born of the current marriage and a little less to the children from the prior marriages. Now, is that always the case? The answer is no. There are times where treating them equally, 1/3 apiece, would be fine. Also, in my earlier example, if the husband was widowed, which means that the child from the first marriage no longer has a mother, then that's even a greater reason to treat that child from the prior marriage the same as the child from the current marriage. It's very important when designing an estate plan that takes into consideration children from multiple marriages, that protections are put in place so that changes to the documents later on down the road don't have an effect of disinheriting a child. So in many instances, I will make trusts irrevocable at the death of the parent. So husband and wife, each having children from prior marriages. When one of those parents die, I now make their trust or estate plan completely irrevocable, meaning it cannot be changed. And I also limit the exposure of the current assets to the surviving spouse, so that at no point the surviving spouse can completely liquidate the estate and thereby disinheriting the child from the first marriage. Always put protections in place for not only the current family, but the prior families. Well, that's been kind of, I hope my zigs and zags with our family here have not been too confusing. I recognize that at some point, a whiteboard and some beautiful stick figures might have been helpful, but hopefully the concepts resonated with you today, especially if you are watching and you do come from a mixed marriage with children from prior marriages. So let's just do a quick recap here. First of all, for those who joined a little late, my name is Chris Nudo. I am an attorney in Illinois with offices in Elgin and Arlington Heights. My practice really focuses on estate planning, real estate, and basic business transaction law. The topic we've been discussing this morning is how parents with children from two different marriages can handle the distribution of assets. And we've talked about a number of considerations, including how did the first marriages end? What is the asset makeup? What is the family dynamics? What are some of the family values? What is the size of the family and how many children come from what marriage? These all being part and parcel of an analysis that really needs to be done prior to your estate plan being done. So then we can establish not only the right vehicles for your estate plan, but also how we're going to draft the estate plan to protect those children from prior marriages. We've had a number of questions that came in today, and I want to just take just a minute or two and review a few of them with you. We really appreciate your participation with us. The first question came in is, what is the best way to equally divide assets or property among children from two marriages? And I touched upon this already, and that is, you don't have to equally distribute those assets. You need to do an analysis of what each child has available to them as a result of their family and from what marriage. And then you can appropriately apportion the assets, and they do not have to be equal. The equality that you're trying to build is an equality as to access. So if a in the previous marriage, if the previous marriage came from a lot of money and that family has great chance for inheritance, then there's going to be less concern about the child from the previous marriage, as it would versus the flip side of that equation, which would be the child from the previous marriage comes from a very disadvantaged position, and now the nuclear family is very advantaged socioeconomically. And so this is the evaluation and analysis that needs to be done when deciding how we're going to distribute the assets. And remember, we're looking for equality, not equal. All right, second question. How can I approach this discussion with my ex-spouse? Wow. Okay, so I'm not really qualified to answer this question because I don't have an ex-spouse, but and what I do recognize is not all marriages that have failed are the ex-spouses cordial with one another. But let's assume, for example, they are cordial with one another, which would be ideal for the children from that marriage. Then I believe it's very important to have a frank discussion about how they are going to treat their child in their estate planning documents. Are they going to leave X amount of their estate to that child? How are they going to do it? And how does that in its totality create a sense of equalness or fairness to that child as it relates to the broken marriage between their families? So I would say if you can have that discussion with your ex-spouse, it is for the benefit of your child. All right, let's see what else we have here. Are there considerations for continuing alimony payments in an estate plan? See, I'm not a family law lawyer. What I do know is this: alimony payments need to be made, no question about it. And should I take alimony payments into consideration when planning my estate? Yes and no. The yes would be, are you carefully considering a spouse or ex-spouse who might have the burden and cost of raising your child? And if you die, will that be a harmful impact on your ex-spouse's ability to raise that child? If you say yes and you care, then taking alimony payments into consideration in your estate plan would be a noble idea. How would you accomplish this? You would not do it by having your estate continue to pay alimony, not in Illinois. But what you would do is you may go out and purchase a life insurance plan, a life insurance policy that gets paid for the benefit of your child from the first marriage as a way of making up for what would ultimately be lost alimony payments if you die. And that is very common. So having an insurance policy in place just in case you die to care for that child as if it was an alimony payment continuing is a very popular and I think wise concept. May I add that I also see it often court ordered, but again, not being a family law lawyer, I can't really speak much more in detail about that. Do you run into issues dividing life insurance benefits between two families? I run into issues where dividing anything is an issue between two families. Life insurance particularly is a good example. Life insurance, though, is just another asset in the estate mix. And so the plan and analysis that we did with regard to the size of the families, what children come from what marriages, what assets are available, and all of that plays into and would equate to the division of assets, including possible life insurance proceeds. What's the best way to start working with an estate planning lawyer? Well, the best way is first to get as much information as you can with regard to your family. So you're coming from a difficult family situation where there are multiple, from a children's perspective, there are parents, uh, there are parents and there are step parents. There are grandparents and there are step grandparents. There are aunts, there's uncles, there's all kinds of family, there's brothers and sisters, all that didn't necessarily all appear as part of the one family unit. It's multiple family units. And you need to analyze what family unit has what advantages and disadvantages as a result of size, socioeconomic status, etc. Once you've analyzed this, then sitting with an estate planning lawyer, we can evaluate, discuss, and come up with an equitable distribution. Note, I didn't say equal distribution, but an equitable distribution. What's the difference between working with a lawyer and doing all the paperwork myself online? Well, this is a very good question. The very simple answer is, if you come from a situation where your first marriage or second marriage have failed and you have children from those earlier marriages and you are now remarried and you possibly have children with the current marriage, or maybe you don't, but nonetheless, none of these real life situations can be adequately addressed in any kind of automated online program. I don't care if you're using Intuit's program, LegalZoom, Law Depot. I mean, I could name dozens of them and Google will glad to surf them up for you. None of these programs are able to adequately deal with the complexity of your life and the complexity of mixed marriages. None. It takes a human interaction with knowledge and the ability to effectively evaluate all of the issues. And so the only way you're going to do that appropriately and well is by working with an estate planning lawyer who has lots of experience in these areas and is happy to spend the time with you to ensure that when you're done with this plan, it represents exactly what you want to have happen for everybody in your prior marriage, current marriage, children from each, etc. Somebody wants to know, do I offer virtual appointments? I do. I mean, is this not post-COVID pandemic? I mean, am I real? Am I virtual? You know, I mean, I get the opportunity to meet with people face to face. I have the ability to meet with people over Microsoft Teams and Zoom, just over the phone. You know, my job is to meet with people where they want to meet. And so, yes, I do offer virtual appointments as well as in-person appointments. And it's my honor each time I get to do something like that. So where can I contact you to set up a consultation? Well, you know, the bottom of my screen will be displaying my phone number to text. You know, give these numbers a call, talk to the myself and the folks in my office, and we can answer questions. We can set up appointments for consultations, and at the end of the day, our job is to make you comfortable that we have your best interest and your family in mind. So I want to really thank you for spending some time with me this morning. I cherish the opportunity to work with you and your family. Your legacy is one of the most important things that you will leave behind. And I believe it's very important that you take the time and plan it adequately, that when you are gone, your legacy is a representation of the good person that you are. Like anything in life, estate planning is a process and it takes some time, not too much time, but, get it started now. There is a point where it's too late. When you've died or become incapacitated, we no longer have the privilege of being able to help you. So while you're still doing well, start this process, get a hold of us, learn a little bit about it, and let us help you plan that legacy. Listen, I invite you to join us here every other week to talk about various topics about your life and your family, and specifically around the topic of estate planning. Feel free to invite your friends, family, coworkers, and please share this video with them if you found it helpful in any way. I hope to see you here again. Stay well and God bless.